Hello everyone, and thank you very much for joining us today. My name's Oshi Fagir. I'm a solicitor here in the Workplace Relations, Employment and Safety Group at Clayton Utz in Sydney. Very happy to be joined by Maurice Baroni, barrister at Denman Chambers, next to me here.
Good afternoon, everyone.
Many of you will know Maurice, who's been a trusted advisor to the transport industry for a very long time. Although I generally don't like to give Maurice compliments, it's fair to say there aren't many lawyers out there who know more about transport industry generally and about owner drivers in particular than he does. So I'm glad to have him here and to hear his thoughts on this issue we're talking about today. Should also say that seminar today is jointly hosted by Clayton Utz and RTO New South Wales. We're grateful to RTO New South Wales and Hugh McMaster in particular for his help in pulling this together. It actually would have been great to hear from Hugh today as well, but he can't be with us today, and he sends his apologies. He sent me some of his thoughts and some questions which hopefully we'll deal with as we go along. So the plan for today is that we've distributed the work in a typical barrister-solicitor arrangement, which means I'll be doing all the hard work and Maurice will swan in from time to time with some words of wisdom and probably corrections.
And that's the way it should be.
We can deal with that that dispute another day, but look, we were hoping to keep this pretty informal and conversational. We're not too wedded to a particular plan, but broadly what we were hoping to do is talk firstly about the way that the courts approach this independent contractor employee question generally and specifically in transport. We'll then talk about the JAMSEC decision, which has arguably put the cat amongst the pigeons. We'll talk about what's changed as a result of the decision and then what you need to do to deal with any risks. And then I'm particularly keen to have some time for questions. You should, I hope, see on your screen a button on the right-hand side, about halfway down that column, that says Q&A. Please post any questions that you have here. They'll be sent through to us. I'll keep an eye out for them, and we'll either deal with them as we go or at the end. So let's get into it. Traditionally, this question of how you draw a line between an employee and a contractor has troubled businesses and the courts for a very long time. In the past, it usually came up in the context of things like the law of negligence, work injuries, payroll tax, those sort of areas. More recently, it comes up often in the context of underpayments, people saying they should have been paid as an employee and weren't, and there are now sham contracting laws. People can be prosecuted under those as well. There have been different tests that the courts have adopted over the years, but they're really along similar lines, which is that the court will look at all of the features of a work arrangement holistically and make an overall assessment about whether the particular person they're looking at is a contractor or an employee. Now, the way a court's put it recently, and I quote, "It involves a multifactorial assessment of the totality of the relationship as ascertained from the surrounding factual matrix with no one matter being determinative." The other way that can be put is to say, if it looks like a duck and it quacks like a duck, then it is a duck. Now, the things that the courts traditionally look at are the level of control that the employer/principal contractor has over the way the work's done, the way the work's paid for, whether it's by the hour, by a result, the level of capital investment that the worker puts into the business, the kind of financial risk that the worker takes on, whether they can, through their actions, increase or decrease their income, profitability of the business. Do they have one customer or do they have a series of customers? All of those things and more go into the mix, and the court makes a call about whether this person's an employee or contractor. And that's all well and good in theory, but in practice, obviously, it creates a real difficulty because it can be very hard for anyone to know whether a particular worker is going to ultimately be held to be an employee or a contractor. So it's created real uncertainty and real risk in this area. Now, that had been the case generally, but transport was one area where things were a bit simpler. And this is probably an oversimplification, but it was basically right, which is that if you brought your own truck, you're a contractor, and if you didn't, you're not. And there are High Court cases, including Hollis and Barbu, which is the case about the bicycle couriers, where at least one of the judges said the conventional view is if you supply a motor vehicle, you're not an employee.
We should also say, Oshie, that there's always been this misunderstanding or misconception about this thing called the 80-20 rule. The 80-20 rule was only ever relevant for the purposes of determining whether an independent contractor was deemed to be an employee for the purposes of superannuation, the superannuation guarantee levy. It really didn't go to the true nature of the relationship. And it's because I've over the years, a lot of people said, 80-20, 80-20, but 80-20 really had nothing to do with any of this, general understanding or determination of whether somebody's an employee or a contractor. It was a completely different kettle of fish, and as I said, really has nothing to do with this issue. I just wanted to make that point.
That highlights another one of the complexities in this area, which is that you have similar but not identical rules about super versus workers' comp versus employment, potentially versus payroll tax and other things.
In fact, on that point, there's a lot of, for example, in New South Wales, and I think similar in Victoria, pieces of legislation, for example, the Workers' Compensation Act in New South Wales and whatever the relevant one is in Victoria, where they have certain deeming provisions, which basically say, well, we understand that you're an independent contractor, but nonetheless, because the way the work is performed in a particular way, or it's an integral part of the business, that you need to fall under the coverage of the workers' compensation scheme. So there's a whole bunch of those sorts of things, but really at the end of the day, in relation to the issue that we're talking about today, none of those are really relevant because they're all deeming provisions within legislation. So it's not at all an answer to what we're talking about, as I said today.
So there was a whole world of pain in this area, but for the most part, when it came to people who were driving trucks, it was avoided because if you brought the truck, you're a contractor. If you didn't bring your own truck, you weren't. No doubt there were cases still where there were complications, but generally that was right. Until recently. And that brings us to the case that we've spoken about, Jansec and Whitby against ZG Operations. Now, this was the case brought by two workers, originally employed as drivers sometime in the early 80s, around the mid-1980s, 85, 86, and at the company's instigation, they went from being employee drivers to owner drivers, or so it seemed. That was certainly what the company thought was happening and what the workers thought was happening, but the federal court had something else to say about it 34 years later. But in 86, what happened was that business essentially decided that it didn't want to keep these guys on as employee drivers, offered them the option of buying the trucks that they'd been driving and becoming LODs, owner drivers. So they set up partnerships, they bought the trucks, they paid their running costs, they eventually registered for GST and started paying it when that was introduced. And to all intents and purposes, they looked like your typical tied owner drivers. In fact, in some ways, they had a bit more independence than some tied owner drivers because they were free to choose what truck they were driving. They were free to kit it out generally as they saw fit. And they set up their own runs. So they were just, the group of them was given the freight to be delivered, and they worked out who was going to do what. And that arrangement carried on from 86 to about 2019 when the company decided to get rid of them. And at that point, two of the workers brought a claim saying that they were employees and had been employees, they said the whole time. And they asked the federal court to award them back pay, annual leave, super, long service leave, and some other things on the basis that they'd been employees but hadn't received their employee entitlements. And I should pause to say, when it comes to the back pay and super component, there's a 6-year limitation period, so they can only go back that far. But when it came to accrued entitlements and annual leave, long service leave, because it just continues to accrue over time, they said, we want our annual leave payments and our long service leave payments on the basis of the whole 34 years that we've been doing this job. Now, at first instance, at the original hearing, Justice Thorley said no, said you're not employees, you weren't employees, you're owner drivers. So he pointed out they bought their own trucks, paid their own running costs, made decisions about how the truck would be fitted out. They had control over the costs they incurred, so they influenced the profitability of the business. They set themselves up as contractors. They signed contracts saying, with contract carrier agreement. He said the fact that they've got one customer, they only ever worked for the one business, is relevant but not decisive. The fact that they were given the freight to be delivered wasn't decisive either, because, of course, any outside courier or transport company is going to be told what to deliver and when. And he said they had some flexibility in terms of how they were going to do the work, whether they had to come back to the warehouse after their deliveries, so on. So Thorley said no. They appealed. And on appeal, the full federal court, 3 judges disagreed. And they said that essentially, on my reading, because the drivers didn't have enough control and autonomy and independence to be contractors. And they said, if these guys work 9 hours a day, 5 days a week, their trucks sometimes were marked with the company logo, they didn't have any real opportunity to work for anyone else, they were told what to deliver, they became contractors after being employees and essentially being given a take it or leave it type of deal, and they couldn't generate any goodwill, which is something that we'll come back to. Now, the fact that these guys had a very significant financial investment in the trucks and then in the running costs, which were equal to about 50% of their income, was barely mentioned. Now, that would have been the start of the end of it traditionally, but here the full court barely touched on it and instead focused on a whole series of other issues. At the end of the day, all 3 agreed that the workers were employees. They haven't made a decision about the amounts, but they've sent that back to the trial judge to sort out. So
we should also mention, Oshie, that the matter is at the moment an application for special leave to go to the High Court. So there is an appeal. We might talk about that a little bit later, and I'll give you what my thoughts are on the prospects of that leave to appeal being successful.
Sure. So look, that's my view of the case and what it involved and how it went. But Maurice, I'm keen to get your views. Can I ask you just your thoughts on a few issues? Firstly, as far as I could tell, although the result was different to many cases that have looked at this before, the court didn't seem to apply a different test. Would you agree with that?
I agree with that. Oshie earlier mentioned to you that the current test, if I can put it that way, that the court uses to determine whether somebody's an employee or a contractor is the multifactorial test. And Oshie described that. Historically, the common understanding was that you'd look at the level of control to determine whether there was an employee relationship or a independent contractor relationship, and by definition, the more control the principal contractor had, obviously the less control the independent contractor had, and that swayed more to a relationship of employee-employer. That has developed over time and broken up into a number of different indicia. And as Oshie said, the level of investment, the level of autonomy, the way that the remuneration is structured. So in other words, you just get an hourly rate whether you do something or not, or do you get paid based on incentive, or in other words, on reward. So the more I deliver, the more I get paid, those sorts of things. And that is the common approach. It's not simply unique to the transport industry, but that multifactorial test is the test that's used by the courts in any form of dispute where there needs to be a determination of employee versus contractor. Having looked at the decision, the contract carriers and the arrangements by which they were working under are very typical of the transport industry. There was nothing particularly, in fact, there was nothing novel about it at all. And in fact, thinking back to all my experience and workings in the transport industry, it's very typical of what happens in just about every transport yard that engages owner-drivers. The only real difference, I suppose, is that the principal contractor or the employer, whatever you want to refer to them as, wasn't actually a transport company, but it was a lighting distribution company, I think. So lighting in the sense of, I think it was chandeliers and that sort of stuff. So it's kind of like, Woolworths and then using its own fleet of owner-drivers to distribute its product. I mean, that's the same thing. So it wasn't a specific transport company. So absent that, it was a typical kind of contract carrier arrangement. And the test that the court applied is exactly what Oshie said, that multifactorial test. So they applied the same test but came to a different view. And it seems to me that there are two or three issues which gave rise to why they formed a different view. One thing that nobody's really talked about, and I think this is important, is the role of the federal court in an appeal. And in this particular instance, what the court was allowed to do was to substitute its own decision. So different courts, depending on what enlivening legislation gives the court the jurisdiction to hear an appeal, may simply look at errors of law. So, for example, I think if the federal court was only looking at an error of law, they might have come to a different view, but they couldn't have found an error in the original decision because Justice Thorley applied the correct test. I think I should agree with me with that. But what the jurisdiction they were working under allowed them to do is substitute their own decision. That doesn't mean that simply because they disagree, they always substitute their own decision, but it's a relevant consideration that I don't think has got much sort of debate. In any event, the other thing that I think really turned this case was back when they started, these guys started as employees, and Oshie mentioned that. Then I think 2 or 3 years later, they became contract carriers. It's not entirely clear to me the circumstances around that, and there's another thing that I'll point out in a moment, but it seems to be that round about sometime in the late 1980s or early 1990s, I can't remember the exact date, the offer, let me go back a step, the company that they were engaged with at the time basically said, look, we're going to change direction, we want to change our business model, this is the new model that we're going to work under, take it or leave it. And that take it or leave it offer was, we'll either terminate you or you can become an owner-driver. And the court put a lot of, it seems to me, emphasis on that transaction. And I'll come back to that, why I think that was important. The other thing that makes this case a little bit complicated is that when the owner-drivers first became owner-drivers, or when they were first employed, they were employed by entity A, which then sold or merged with another entity, which then sold or merged with another entity. So there was a long history of lost information, I think, which made it perhaps difficult to understand exactly what originally had happened. But nonetheless, what it seems to be clear is that there was a sort of, this is what we're doing now, we're changing our model, and if you want to keep working with us, you need to work under this new model, otherwise, see you later. And the court placed a lot of emphasis on that, and I think what swayed them in relation to that was that, well, was this really a genuine bargain in the sense that, did everybody really genuinely intend to enter into an arrangement which was beneficial for both parties by becoming an independent contractor? And there seems to be a bit in the decision about this. That obviously wasn't the only issue that swayed them.
But just on that point, Maurice, it's interesting because employees are retrenched every day of the week as businesses make decisions about how they want to organise themselves. There are people who are given take it or leave it deals. Every time you apply for a job, you're usually being told this is the rate and you can take it or you can find a different job. So I did get that same sense that the judges thought these guys had been hard done by, and maybe that's why they were keen to give them something. But on actually looking at it, maybe the company would have been better off saying, we're moving away from an employee fleet, here's your redundancy, see you later, and bring in 5 new guys, and they may not have had this same problem.
Look, that might be right. It's hard to predict how the court would have reacted in those circumstances, but it is clear from the decision that seemed to have troubled the full court, that particular event. And as I said, that wasn't the only thing they looked at. They looked at other things as well, but that was a defining point, which I think I got out of the decision. But as I said, they looked at other things, and Oshi's touched upon these. Whether in fact these guys could actually work for other people. Now, I think this raises an issue, and we should say that there was a contract in place for these guys, which had various variations to it along the way. But the effect of it was, and I've seen parts of it, it's very typical of a contract that exists even today in New South Wales and probably in other states about, the relationship between owner-driver and principal contractor. It is very typical that it sets out, you've got to deliver the product when we need it, all this sort of stuff, and you've got to supply a vehicle and maintain it, all the usual bits and pieces. There's nothing remarkable about the contract. And these contracts also have, you generally speaking, not all of them, but a lot of them stipulate the hours you've got to provide, you've got to be available for. And I think that's a factor also that the court took into account, because I think from memory the contract said, well, they've got to provide 50 hours a week or something or other. Was it something like that? Anyway, the court then said, well, if I have to provide contractually 50 hours a week, can I actually genuinely work for anybody else? Now, the answer to that might be, well, yeah, to a certain extent you can, but they took a different view because don't forget, as Oshi said before, what the task of the court or even tribunals in adopting or implementing this multifactorial test is to sort of, have all the bits and pieces of the puzzle, all the things that people do and are required to do and aren't required to do, stand back and look at it objectively and look at what is happening in reality, and then applying that test to the reality of what's happening. So not just, the contract says X or the contract says Y. And that's why, even though on one view you could say, well, they're only working 40 hours or 50 hours, they could work for somebody else. And the reality is, can you really actually meaningfully work for somebody else if you're tied to your principal contractor for 50 hours a week or 55 or whatever the case may be? So these are sort of, where the court sort of applies their own opinion to the facts. And that was another thing that seemed to sway the court in coming to its conclusion. The other...
Maurice, on that point, these guys, there wasn't a very clear description of what trucks they were driving or what they were actually carting, but they seem to be some sort of fairly generic, multifunctional vehicle with a tarp maybe that had the company's logo on it. And if you think about many owner-drivers out there who are fully kitted out in company livery, and those who have specialised equipment, powder tankers or concrete agitators or whatever. I mean, there's no way realistically that someone like that's going to be able to go out on a weekend and cart with someone else.
Yeah, and
So
I think that
the same issue must come up.
I agree, because the trucks, there's some pictures, there's some photos of the trucks in the decision, actually, and they're simply single bogey rigids with taut liners, and the taut liners had the name of the company on the side. Now, again, that's very, very typical of a tied subby, be it in New South Wales or anywhere else. And I think they're the sorts of things that would seem to have swayed the full court, at least in part, informing this objective view about, well, can they really work for anybody else? I mean, how can you, if you've got, I'll just pick an example, if you've got tolls sprayed all over your truck and you actually go and work for Linfox on the weekend or whenever you've got free time. I mean, I think the obvious answer to that is no. It just doesn't make any sense, even if you could do it. So they're the sorts of things that I think swayed the court in relation to those sorts of matters. On one view, you kind of, I've asked myself, and I've spoken to Osh about this, has the court really made the wrong decision? Maybe.
That's one of our questions, is this decision an outlier and clearly wrong? The questioner says, I think the High Court will overrule it.
Yeah, I mean,
just in answering, bear in mind that we're being recorded.
Yes, we're being recorded.
Any one of these judges could get on the Clean News website and listen to exactly what you're about to say. My view about the decision is, whilst it might be wrong in inverted commas from a practical viewpoint about what actually happens in the transport industry, and I kind of say that a little bit loosely, it was open to the court to make that finding because it's a matter of fact, and it's difficult to be critical of courts when they simply apply the right test, apply it to the facts which don't seem to be in dispute, and come up with a particular view. So there was no sort of real error of application of the law, in my view. That then leads me to the point that I was making before, and I said there's an application for special leave to the High Court. What that means is that before the court will hear an appeal from a lower court, the High Court that is, it needs to be convinced that there's something special about why it should let the appeal run in the first place. And those special leave applications generally, each side has 15 minutes to convince the court why special leave should be granted or not granted, and there's a little red light that when the light goes off, you've just got to shut up and sit down. The buzzer goes off.
Yeah, the buzzer goes off, and that's the end of it. So my view about the special leave application is that it will fail, and it will fail because what the real challenge is are the facts, and it's really difficult to overturn, as I've said before, a judge or judges that have based the right legal test on the facts, because the facts are open. Unless there's something completely ridiculous about the way they've dealt with the facts. So, for example, this is a flippant example, but the obvious uncontested fact is that the sky is blue, and they've come to the conclusion that it's red. That will be an error. But there is nothing that I can see about the facts in this case where they got the facts wrong. The facts are the facts. So it's really they've applied their judgment, which they're entitled to do in relation to the facts, and applied the correct test. That's going to make it really, really difficult. Having said all that, it's not entirely clear to me, and I say this cautiously, but that this decision opens the floodgates. Because each case turns on its own facts. You've probably heard that phrase 1,000 times, but I think there is this issue at the beginning of the history of this case, where there was this ultimatum about, take it or leave it. Now that does happen commonly in the transport industry. So I mean, it is a dangerous decision that at the moment kind of says, well, at least these two guys are employees for the purposes of at common law. I think
one of the sayings that some lawyers have is bad facts meet bad law, and here,
yep.
on one view, I don't know if this is right or not, but the judges saw these guys, felt some sympathy because of that specific issue, decided to get them up, but that might have unintended consequences for a lot of other businesses and some owner drivers who are sometimes quite happy being subbies and who would be offended if anyone told them they're an employee.
The other thing that the court focused on is this issue about goodwill, and most transport operators and the attendees today would understand this concept of goodwill. It's not entirely clear. One of the judges in on the full court, and in fact, it was the full court agreed with this description of goodwill. Goodwill in the transport industry, as we know it, has quite a different complexion, if I can put it that way, in relation to what goodwill generally is in a commercial sense. And the company had argued that, and there was provisions in the contract for this, and the provision I think was, well, you can't sell the contract in effect, without our approval. That was the effect of it. So, and the judge below, Judge Thorley, said, well, that means you can sell, and if you can sell, it doesn't say that you can't sell. You can sell, but there's some qualification to it. And so his finding was, well, you can sell goodwill, and that's another indicia of weighing in favour of there being an independent contractor relationship. The full court said, well, that's not really right, because when you look at it again objectively, forget about what the contract says, but what have these people actually got to sell? You can't really, and they looked at it from a purely commercial sense, and Justice Perrin was the one that really articulated this, and I agree with him. They really never have anything to sell. What happens in transport, and it's most obvious in New South Wales because some of you may be aware there is this legislation in New South Wales that deals with goodwill issues, that is contract carriers buying and selling in yards and all that sort of stuff. But the concept of goodwill under that legislation is completely different to goodwill in a commercial sense. A typical owner-driver, for example, in the breweries or the concrete industry or the brick cartage or in general transport yards, you don't really develop a run, you don't develop customers, you don't develop anything that you can really sell. There was just this crazy thing that happened over the last 50 years about, owner-drivers introducing people and getting rid of their truck and getting a premium for the privilege of working in the yard. That's all they were really selling. And that's the way the court actually distinguished it by saying, well, there's nothing, you don't develop anything, you've got nothing to sell other than your truck maybe, and that's just worth what it's worth. So I think they're right about that. And I think that then leads us into this real quandary, particularly in relation to New South Wales, which I think we're going to get onto now.
Yeah. Well, can I just interrupt you before we come to that? I'll just deal with a couple of questions, and then, Morris, I do want to raise with you the Chapter 6 issue, and we have a couple of questions about that. And one of the questions we've had from Paul Ryan, hello, Paul, is how did the court deal with the fact that these two, or actually the whole group of them, there were 5 of them originally, 2 ran the case, were claiming expenses as a business. In fact, they were claiming expenses, they were remitting GST, the company wasn't withholding payroll, all of those sort of formal trappings were consistent with being contractors. And Justice Thorley at trial spent a bit of time talking about that. And as he pointed out, there are cases where the judges say, look, you can call it whatever you like, you can dress it up as whatever you like, I'm going to look at what's really going on. There are other cases that say you can't just ignore the fact that someone's been claiming deductions on the basis that they're a business. you can't ignore the fact that someone's registered for GST and carrying on, as far as the ATO is concerned, a business. Those are all things that really count. And Thorley, at first instance, gave that some weight and said, this wasn't a matter of someone just being signed up to some contract that they never read, saying you're a contractor when it was obviously not true. So these guys, they established partnerships, they got accountants' advice, they split their income, reduced their tax liability, and all of those things matter. Full court, on the other hand, said it doesn't really matter. They're just formalities, and we're going to look at the way the work was carried on.
And I think, again, what swayed them, or their view about that, was you got to put it in the context of the original engagement, that is, take it or leave it. So they asked themselves, I mean, it's not entirely clear from the full bench decision, but they certainly did not agree that the simple fact that they were carrying on a business, if I can put it that way, was indicative of it actually being a genuine business, given the historical genesis of the relationship. That is, they had no choice. That's what they were told to do. Take it or leave it. So that's what follows. That's the only way you can do it. So I think that was part of the analysis.
34 years later, they were still...
Yeah. It doesn't make a lot of sense to me. But again, the problem you've got with this multifactorial test is that is just one indicia. So you can have, and I've seen a number of decisions where the courts have said, well, these are the 10 things that are relevant in this relationship. 4 of them support a proposition that they're an employee, but the other 6 support a proposition that they're not. So therefore, taking everything into account, I conclude that they're not an employee. So it's a question of weighing it all up in the overall scheme of all the indicia that the court looked at. But Justice Thorley had clearly said, well, they've represented themselves as carrying on a business. That's what they've represented to the tax office, to everybody, to the whole world. You just can't sweep that under the carpet. Full bench took a different view, that it had some weight, but not enough weight to sway them to support Thorley's view of that.
Now, Maurice, I want to ask you about Chapter 6. And for those of you who are with us who are not New South Wales based, Chapter 6 is a part of the New South Wales Industrial Relations Act that deals with owner-drivers or contract carriers in the language of the Act. And so it's, if you are a contract carrier, which is basically one man, one person, one truck, you have certain entitlements, including under contract determinations, which are instruments that set rates of pay for some owner-drivers, not all, but many. Now, one of the questions that we've been asked is, were these fellows paid under contract determination? That they weren't, and one of the extraordinary things about this case is that Chapter 6 contract determination words don't appear in it. But they were paid a standing rate and running rate, and I haven't actually sat down and compared the figures to what the determination was at that point in time, but they looked to me on the face of it pretty similar. So they got their per kilometre rate, their hourly rate, which is the way that payment's structured under the general carrier's contract determination, which applies to many owner-drivers in the Sydney region. Now, the question that we've been asked is, what does this mean for Chapter 6? Does it mean it's a dead letter? And does it mean, that's one question. Second question is, if you are applying a contract determination, is that a good defence to this sort of claim that someone's an employee?
Can I answer that question this way? There was no, in the first instance decision before Judge Thorley, there was no argument about the role of Chapter 6, the role of contract determinations at all. The defence was purely run on, the multifactorial test, that is, that they're not employees. That's the end of the story. And as I understand it, having spoken to one of the counsel that appeared in the first instance matter, in fact, the counsel that appeared in the first instance matter, he told me that was strategically done because if they had run an argument enlivening or debating Chapter 6, it would have been problematic because the guys had been made redundant effectively, and therefore then the redundancy entitlements arising under the redundancy determination would have applied.
And again, for our interstate attendees who are wondering why we're talking about redundancy, there's a contract determination in New South Wales that establishes redundancy entitlements for owner drivers, and it can be pretty pricey because it's not just the hourly rate; it's a big chunk of
the whole rate
that's being paid.
And so then so it was a strategic decision. So a little bit of background about Chapter 6 for those that aren't particularly aware of it. It's a provision in the New South Wales Industrial Relations Act that's been around since 1979. It has the power to make what are called determinations, which are virtually the same as awards, which create minimum terms of minimum entitlements for owner drivers, obligations and rights. So they set, importantly, what everybody really cares about is they set minimum rates of remuneration for an owner driver for the time that they're engaged. The power of Chapter 6 or the Commission is also to reinstate owner drivers that have been unfairly dismissed, same principles as employees. They can make disputes, they can hear disputes and then make sort of limited orders, but we don't need to worry about that, but they can deal with disputes. And the other thing, obviously, as I mentioned earlier, they can deal with issues of goodwill. So when somebody's paid goodwill and then, paid $400,000 for a run and then they get terminated 6 months later, then generally speaking, they have a claim to recoup some or all of that money. We don't need to go into it. So there's a very unique jurisdiction in New South Wales. The problem with this decision that it creates is that it creates this obvious conflict, I think, because in New South Wales, the reality is that if you agree, that's probably not the right word, but if the relationship is, at least on its face, one of principal contractor and contract carrier, then assuming that relationship falls within the definition, as Oshie said, of Chapter 6, that is one man, one truck kind of thing. It's a bit more complicated than that, but that's essentially what it regulates. Then you're captured by the Industrial Relations Act and you are obliged to pay the rates in the relevant determination. For the purpose of our discussion, the most common determination is general carrier's determination, which probably affects most of you, if not all of you, on this webinar. And you're bound by it. It's enforceable. You can be prosecuted if you don't pay it. The underpayment issues arise. Obviously, apart from the obligations to pay, just like awards, as I said, if you terminate one of them unfairly, then you fall within the jurisdiction. If you make them redundant, then you've got to pay redundancy. There's all those sorts of things which enliven or are there to be dealt with. And it creates a real difficulty because on the one hand, in New South Wales, you're actually captured by a jurisdiction that says, well, for the purposes of this legislation, they're owner drivers. And remember that it's for the purposes of this legislation that they're owner drivers. It doesn't make any findings, or it doesn't say that at common law they're employees. It recognises them as contract carriers. So you're stuck with that on the one hand, and then you have this risk whereby somebody can come along and run a case like we've just been talking about, which turns that whole relationship on its head. So how do you deal with that inherent conflict between the common law and the jurisdiction of Chapter 6 that you actually have no choice but to operate in if you choose to engage an owner driver? So you can't simply say, well, I'm not going to recognise you as an owner driver. I suppose you could and make them an employee, but that's the choice you have. You either make them an employee or they're an owner driver, and if they're an owner driver, they're captured by Chapter 6. I'm not entirely sure how that conflict is reconciled going forward, but it really creates a conundrum, particularly in New South Wales. The other thing that this problem creates is that, again, getting back to the decision we're talking about, as Oshie said, there's been a declaration that they're employees for a common law. That means that a number of things follow. Now, firstly, as Oshie pointed out, long service leave obligations, they're entitled to those. Annual leave obligations are entitled to those. They're entitled to all the benefits which arise under for these guys, the Road Transport Distribution Award. They're entitled to the benefits of the Fair Work Act. So there's a number of things that flow from that. In a nutshell, that means, well, I'm entitled to a whole bunch of money for those breaches. That is because I haven't been paid overtime, I haven't been paid annual leave, I haven't been paid for my public holidays, all that sort of stuff. They're obvious what they are. But at the same time, I've been paid for the last 34 years an amount of money, and let's assume for the purposes of the argument that it is in accordance or better than the rate of remuneration in the general carrier's determination. Let's just assume that for the moment. So I've actually complied with that, but now that's all meaningless because they're employees, but I've still been paid that amount of money. How do you reconcile what the underpayment is? Because the amount of money being paid to them when they were contract carriers also includes, in New South Wales anyway, because the formula mandates it, an amount of money in recognition of long service leave, an amount of money in recognition of annual leave. I think it even has an amount of money in relation to public holidays and a few other bits and pieces. Then you've got to somehow extrapolate all that and work out, well, what part of that money is labour, what part of that money is running costs and fixed costs, and somehow this exercise has to be done about what the court will ultimately say, well, these are the underpayments versus what you've been paid. So maybe your eyes are glazing over as I'm speaking about this. The other issue that it raises is this, and there was a recent full court decision of Rosato, which some of you may have heard about. It's whether somebody was a casual or not a casual. But the question that arises is this. If there is no clear provision in the contracts, well, let's assume you don't have a contract and you're just relying on the contract determination about offsetting, there may be no offsetting ability. That is, that you can't offset the payments they have received against the payments they're due to receive because of the breach. This sounds a little bit complicated, but can I assure you it is, and it's a real problem that there may be no ability whatsoever to offset the money they've got for the last 34 years. Let's just use that time frame for the sake of the argument, to what they should have got. Now, obviously, as Oshie said, there's a 6-year limitation on that, but the annual leave and the long service leave, there isn't. So it really creates an enormous difficulty in understanding, well, what on earth do you do? Particularly in New South Wales, where you can legitimately engage somebody as an owner-driver, they're recognised as an owner-driver under the Act, but you have this potential risk of other people now having a crack at that relationship, particularly in circumstances where, you've had owner-drivers that have been working with you for 10, 15, 20 years in exactly the same circumstances as this, and they've got, your company name splattered all over the taut liner, the truck's painted in yellow, green, blue, or whatever the case is. They don't really ever work for anybody else because they can't, et cetera, et cetera. So,
Morris, can I just on that topic raise the question that I suspect is on everyone's mind? The law's the easy part. We can talk about that uphill and down dale, and we have and will continue to. I suspect what people are really asking themselves now is, what do I need to do? And that's the harder part.
Yeah.
Can I give some thoughts, and then tell us what you think this means for the industry? The first thing I would say is, I say this to clients who are not in transport all the time, the only way to eliminate independent contractor risk is to not use any individual independent contractors. You can go out there and get a fleet owner in, or you can go out there and get a plumbing company or whatever it is. But if you've got one person engaged as an independent contractor, there is always going to be risk. It's as simple as that. Number two, having said that, don't panic yet, because what's happened really as a result of this case is that the transport industry is now no better off than everyone else. But there are thousands of businesses out there who do use independent contractors and who carry this risk every day. And the proportion of them who are ever actually prosecuted is pretty small. It's a bit like this Brisado thing where we've got all these long-term casuals. Everyone's legitimately very concerned that they're all going to be entitled to annual leave and double dip and so on. But the reality is the number of times that actually happens is pretty small. So it's a risk, but it's not something that's certain to materialise. Although if there's a High Court case about it and puts it up in lights, maybe that the risk increases a bit. The third thing I would say is that I think there are some things you can do. And bear in mind, I think as Maurice has said, this case, it's not necessarily that it's wrong, but it's about its particular facts. If there's another case, the court will have to look at that all over again. And if people haven't, gone through the same process as these guys, the result might be different. But here's what I'd say to try to mitigate your risk a bit. Number one, don't involve yourself in buying or financing the truck. And in this case, one of the issues was the guys were driving the truck as employee drivers one day. They had to buy that truck from the company the next day and carried on almost unchanged. In my mind, just stay away from all that, because the more involved you are, the more it looks like you're effectively providing the vehicle indirectly, the more trouble you're going to have.
And of course, they did upgrade their trucks over the years. So but the starting point is a really important point in this case, I think.
Yeah. Second thing, don't force anyone to become an owner driver. It sounds a bit stupid, but it's essentially what the court found here. If you are going to move from employees to owner drivers, then it's got to be, if you're going to keep the same people, it's got to be crystal clear that it's their choice, that if they don't want to take this path, that they can take a redundancy or whatever else. Third thing, this seems minor, but I think it could actually be really important. Make it clear that if the particular driver's on leave or something else, they can put someone else in. And if you can arrange yourself so that when the driver's not working, someone else is driving the truck as opposed to you covering it by bringing in an outside hire or whatever else, do it. Because that idea of whoever drives the truck, you're not wedded to that one person, can be important in this legal analysis. Now, you might say to me, I don't want some random turning up and delivering to my clients and doing God knows what. You might say to me, I've got very good reasons to make sure the truck's kitted out in my livery. I understand there are a whole series of commercial factors that dictate what you do. It's not as easy as just saying, well, there's a case that, produced this problem, so I'm going to, upend my whole business to fit into it. I'm not suggesting you do that. At the end of the day, you've got to run the business and try to make it work. But those things, I think, are some points that will help. But I think it's something we're going to have to continue to think about. I'm racking my brain trying to think of a solution. I have to say one's not leaping out to me, but we just need to keep thinking about it and working at it. In the meantime, those are some small things that might help. Maurice, we're about to run out of time. I mean, we probably, in hindsight, should have allocated a bit more time to this issue, but can you give us your thoughts on what should our listeners, our attendees actually do in light of this decision?
Well, I mean, I think as far as practicable, one answer might be a bit drastic, but try to avoid using owner drivers. The second thing is, if you do use owner drivers, as Ossie said, engage them independently in the sense that, they're not ex-employees or they're employees that have been terminated and they come back as owner drivers. Go to the market perhaps and I'm looking for owner drivers, put them in the paper, and then they come on willingly, because that is a very important aspect, that they come on willingly And genuinely, when one looks at the transaction, you put an ad in, some bloke says, I've got a truck, I'm happy to be an independent owner driver. I think that's really important. I guess the other thing is, if at all possible, and if you do have written contracts, and you might want to have written contracts, but they're not they don't tie the person up in knots. That may not suit your business model, but, I guess if you could at all avoid having the truck in your colours, if you could at all avoid saying, well, you must work for me 50 hours a week, if you could at all avoid those mandatory placing those obligations, and in particular, you can only put somebody else in your truck with my permission. There's probably a whole host of things, but they're the sorts of things that I would suggest you'd start having a look at now. I don't think they're a complete solution to this problem, but there are some
of those formalities, what seem like technicalities.
They're very important.
Practice, if you end up in court, they can really make a difference. Like, do I have to give you permission to put person X in the truck this particular day, as opposed to do I just have to approve, a group of people? A lot could turn on that type of, seems like a technicality, but it could really count.
Well, I think those little technicalities were very important in the thinking of the full bench, I must say. So they're the sorts of things that I would suggest you have a bit of a think about.
Look, we're about to run out of time. Can I just say, I'm not speaking for Morris, but certainly speaking for myself, I'm happy to continue this discussion offline. It's too bad. In the old world, we would have had a chat afterwards. I'm happy for anyone to send me an email, LinkedIn, whatever, just bounce around ideas, thoughts, any ideas that people have, because the answer's not obvious to me. So I'm certainly speaking for myself, happy to continue the conversation offline. And I'm sorry, we had at least a couple more questions that were good ones, including whether we need a new classification of dependent contractor that were worth talking about. But
it's a matter for Parliament.
Yeah, and between Uber and Deliveroo and a bunch of other things, this is, most of it does seem to be transport related for whatever reason, not necessarily freight cartage, but other forms of transport. It's a big issue. It's not just a problem for the transport industry. It's really something that Parliament sooner or later is going to have to come to grips with. And I suppose the other thing is stay tuned for the High Court special leave application. That could make a big difference.
I wouldn't get too excited about it, but let's see what happens.
Yeah. Okay. All right. Well, as I understand it, we cut off strictly at the end of our time. So, thanks very much, everyone, for joining us today. Obviously, a difficult issue and an important one for this corner of the world. And as I said again, very, very happy to continue the conversation offline. And thanks very much, Morris, and thanks Hugh and RTO for helping us pull this together.
Thanks, everyone. Thank you. Thanks, Archie.
Bye-bye.